will not leave them behind. Welcome, students. My name, you guys do know who I am, Kamukelo Mashego, and I will be introducing myself when I present my heads of argument. So this is a very exciting setting in which today I get to be judged by the people I judge. I get to be roasted by you guys. That must be exciting for you guys. And I hope you guys are going to bring a whole lot of questions to the fore. But before I present, I would love to just welcome you guys to the meeting and the sitting. And I will hand over to the judges to give you guys feedback on what you guys were, where you guys erred in your judgments, in your arguments, and just to so that you guys next time when you participate in musical competition, you do know what to fix. You do know how to position the camera, I guess, how to give us your information, allude your information to us in a very articulate manner. So I will start with one of the judges, Ms. Obakeng Mulimi, and I will be admitting people in the lobby. So when you see me busy here, it means that I'm admitting. So Obakeng, over to you, and then you do know how it's going to circulate around the judges. Sure.
Good morning, everyone. Mr. Mashal, can you please just confirm if you can still hear me?
Yes, Obakeng, I can hear you.
All right, thank you very much. First of all, thank you to everyone that is here. Thank you guys so much for participating and being confident and bold enough to come and present. I'm not going to touch on a lot of stuff, just the basics. Ms. Durant and Ms. Boita will be more comprehensive, I believe, than I will be. I just have 4 points that I made out, and I'm just going to rush through them quickly, and then we'll move on to the next judge. First of all, I made a note that I would really advise that you all go and watch the training that we had late last month. I think it's very important and vital that you watch it and you just take note of everything that was mentioned there, especially court etiquette, because that is something that we picked up that was lacking throughout a lot of the presentations that were made. And secondly, remember that law. Is someone about to speak, or please mute your mics, please. Thank you. Secondly, please remember that law is very fact-based. So when you make a statement and you bring forth an argument to the court, ensure that you have authority as well as case law or anything that will support what you are saying. And when you do that, don't just state it and merely move on. State it, elaborate and explain on it, and then just briefly tell the court why you decided to use that specific authority so that you can tie it properly into what you're saying and understand that you do understand the authority you're using and you're not just throwing in authority for the sake of throwing in authority. Also, confidence is golden. Please be sure and understand what you were saying, and that will give it a more persuasive and a little bit more weight, just as much as you will use your authority in it. But be careful, the judges are not stupid. They know the facts. They know many of the scenarios that you can use with regards to the facts. So when you are confident, make sure that what you're saying is something that is very constructive and makes sense, because you will be able to pick up the rubbish, if I may say, that you were saying, even though you're presenting it confidently. And lastly, please be prepared. Prepare your presentation like you used to prepare your speeches in high school and primary and for the class. Because when you're not prepared, there are a lot of moments where you will say, and those very destructive and very distracting, if I may say, interjections or phrases. So when you're well prepared, you will be confident and you will flow through and you will know exactly what to say. And should the judges stop you and ask you a question, you'll be able to adequately respond and be able to just move back to what you were saying without having to hesitate and take through your pages again and figure out what you're saying. So be prepared like you would be for a proper oral batch that you did in high school. And that is it from me. Very short, very brief, and practical things. Now we will move on. Thank you.
Thank you so much, Ms. Obakeng Molini. We're extremely thankful and grateful. Tobeka, over to you.
Am I audible? Okay. So, the very first thing that I'd like to talk about is knowing your facts very well. Okay, I'm going to keep every single time when I state a point, I'm going to refer back to the cases or the facts of the case that you guys proposed, present. Now, knowing your facts, there's some like a very limited amount of participants who are able to, spot certain things that, were in the facts. For instance, that when the complainant heard the sound, he heard the sound of something unlocking, but there was a brick that was found with a window that was broken. So it's those little things that you need to be careful of, and you need to identify while you're reading the facts. So when I say you need to know your facts, I mean that normally with your mood court and the set of facts that they're going to give you a lot of things that contradict each other. So you need to be able to identify such things and know them. So when you give your argument, then you're very clear about what you're talking about. So firstly, you need to know your facts. The second point that I'd like to go into is the way in which you address the court. Now, like Ms. Obakian said, please go back to the training that we had. It's going to help you a lot. But some things that I actually did realize is the fact that you guys did not know who the presiding officer is. How do you address the presiding officer? Very important. Like Mr. Herman said in the training that the presiding officers, the professional presiding officers get really insulted when you refer to them in a way that you're not supposed to refer them. Takes away the point, takes away their confidence in you. So please be very, very careful of that. Know the people that you're referring to. And then the other thing is, I wanted to first ask this question that when you're in someone's house, what do you normally do when you want to do certain things? You always ask for permission. So that's the thing that you need to do in court. Before you give us your statement, you should say, if it pleases the court, may I proceed? This is my issue. Be very, very careful with that, because at the end of the day, you're trying to charm these presiding officers with the way in which you're going to address them. So always, when you want to address something, when you want to give out an issue, if it pleases the court, may I? Even when they ask you a question, you need to say, if it pleases the court, may I answer that question? Be very careful with such things. It's very important. Third point is, you need to provide us with the issues that you have identified. Please just don't go into your arguments without telling us what you're going to talk about. The presiding officers need to be aware of the things that they are supposed to expect from you. So if you're going to talk about the issues, tell them this is the first issue that I'll be talking about, which is the admissibility of hearsay evidence in this court. Then you go into it and you talk about it. So whenever you have to now substantiate your argument, we know what the issues are that you have identified, and we know what we're expecting from you. So that's very, very important. And then the other thing is the use of authority. You cannot go into a moot court and tell us that you did not find the case or you did not find certain information. You can't. You need to have them, look for them like a mad person. And I promise you are going to find it. So whenever you have to, substantiate your argument, use case law, use legislation in things. Now with case law, I need you to identify these things. I hope you're noting down these things, man. With the case law, you need to know the facts of that case that you're going to say. Okay, well, because chances are you're going to talk about a case and the presiding officer is going to know that case very well. So if you don't know those facts of that case, then it's going to be a bit of a situation for you, because if you say something that's irrelevant or that's not correct according to that case law, the presiding officer will call you out on it. That no, that's not how the case, the facts of that case went by. So you need to know the facts of that case. Second, you need to know where that case was heard, because it tells you whether it has a binding on the court that you are presenting or you are addressing at that current time. So you need to know such things. You need to know whether or not that case was appealed or not. Because if you refer to the case that was read by the High Court, but then was appealed in the Supreme Court of Appeal, then the decision changed. You can't now use the decision that was used in the High Court. You understand? So be very careful of such things. You need to know, you need to state why the case needs to the case or needs to hear the case that you're referring to. Convince us that that case that you're talking about is the right case that will determine the outcome of that case, or that case that you're addressing at that time. Okay, so that's everything that you need to know about things. So when it comes to legislation, be very careful also with legislation. You need to, first of all, take that legislation. So we need to know which legislation you're talking about. Refer to the specifics of the case. So if you're talking about the Children's Act, Section 3, Section 4, be specific. Don't just say the Children's Act. We want to know which section you're talking about, right? Second, you need to know whether or not that legislation has been repealed or it has been amended. Because if it has been, then you need to use the amended part of it, not the original part of it. So be very, very specific when it comes to case law and legislation in that aspect, right? And lastly, when it comes to legislation, use it accordingly. So if you have your arguments and your arguments are based on that specific legislation you'll be talking about, you need to be very careful and very specific on the relevance of that legislation to your case. So don't just talk about a children's act, whereas we're talking about a criminal case. Be very, very relevant when it comes. They need to coincide. They need to be the same. You understand? I hope you noted that down. Then the other thing, but Ms. Overkin talked about that, is the confidence, right? And when I say confidence, I mean I don't say that you need to be the best in English or whatever. No, but when you're talking about something, have conviction in it. You understand? Speak with conviction, because if you don't, the presiding officer will hear that you don't have confidence, and if you don't have confidence, they won't have confidence in you and your argument. So you need to speak with conviction. Please speak with conviction and show us that you know what you're talking about, and nobody can take you out of that situation, or no one can convince you otherwise. Then the last point that I had for you guys is, when you're answering the questions that are posed by the presiding officer, normally in Moot court, they're going to ask you questions that are based on authority, right, on legislation, on case law. When you answer those questions, make sure that you answer with those cases. For example, the Moot court that we had yesterday with you guys, we had a rubric, and in the rubric we had to give you a point on whether or not when you answered you used case law. So be careful with that. When you answer, this is law. You need to do a fact. You need to do with the laws that are real. So if you don't answer us with case law and other authorities just like legislation, then what are you talking about? You understand? So basically, that's it from me. But other than that, guys, your presentations were really good. And thank you so much for participating. That's all from me.
Okay, Tobeka, kindly mute yourself. There's someone in the lobby, not in the lobby. Guys, please mute yourselves. You will be given a chance to speak, especially when you have to ask me questions. So kindly mute yourself right now. Let's move on to Danielle. Who is sharing their with us? Yeah.
I think it's Obakeng.
Obakeng, are you having problems there? Okay, kindly, Tushante, can you just press over there, stop presenting over there on top, on your laptop, where it's written stop presenting, yes.
Yeah.
Press it, then it's going to remove it. Okay, it will be removed, I think, in due time. Thank you.
Right, guys.
Danielle, over to you.
Okay, thank you, Kamu. Obakeng and Tobeka already addressed my points, but I'm just going to state it as I saw it. My first problem was court etiquette. Like, in South Africa, you don't refer to a magistrate as your honor. Never. He's going to be so mad if you refer to him as your honor. It's always your worship. So please take note of your court etiquette. And like they also said, it's always, if it pleases the court, may I continue. So please just take note of all your court etiquette, and just go back and look at our junior Moot training. Herman really stated it perfectly there. The second point I want to address is the set of facts. Really know your set of facts. That is really true. Just know your set of facts. But when the presiding officer asks you not to recite it again, don't do it. Go straight to your argument. They know it. And hearing it over and over again is going to put a little bit of frustration within them. So that's the second thing I wanted to address. The third thing is authority. You need to have case law and legislation to support your argument. I can't stress this enough. Case law and legislation is one of the most important things that you need. And I want you to please look when Kamu presents how he applied it, how he linked the facts and the case law and the facts and your legislation. Please just note how he does that. And then the last thing is self-doubt. The court shouldn't convince you. You're supposed to convince the court. And when you self-doubt, I see you come. When you self-doubt, that's going to make the court not believe you. So please just keep that in mind. Be confident. Even if you think that you're wrong, be confident with your answer. So that's all from me.
Thank you so much, Danielle. And the reason why I was so touched by your point of the court needs to you need to convince the court, not the other way around, is that the student was right. The student was presenting so much, so well. And I was like, you know what? This one is good. Let me mislead the student and say, in which court are you appearing before? It's like, yeah, I'm appearing before the magistrate court. And the student referred to case law and saying, okay, or where do you hear the case? Where is the case from? Says it's a high court judgment. I'm like, oh, okay, we're getting somewhere. All right. And then I say with my face straight, and is the high court judgment binding on this court? So are you trying to tell me that the high court judgment is binding on me? You know, the student was so scared. The student just couldn't face me. I don't know. I am not. Guys, the High Court judgment is binding on the magistrate court. Say it with so much conviction that no, it is binding on you as a magistrate. You need to follow the precedent that is, come on. Like, it's simple as saying, yeah, it is binding on you. Oh, okay. I am a lower court after all. Thank you so much, Danielle. Toshante, over to you.
All right, thank you so much, Kamu. Am I audible? All right, so a lot of the points that I wanted to touch on has already been addressed by everyone else. There are some things that I am going to make reference to. However, I think you guys are able to tell by the feedback that we've gotten from everyone up until this point, we really encountered similar problems in every participant, and I really think that it's important that you guys, you take note of it, you go back to that YouTube video, you watch it, you look at the set of facts again, and then you perhaps see where you went wrong or areas that you could have improved. But the first thing that I really want to touch on is the set of facts. Taweka mentioned that it's very important for you to know your set of facts. Along with that, whenever a student joined, the first thing that Mr. Mashiko said to them was, please do not reiterate the facts. And that is because we have probably heard about 30 students or more. So you can understand that by the time you are presenting, we are very, very well acquainted of the set of facts. So also with that, when you do choose to reiterate the facts, which we strongly do not recommend that you do, but please do not make reference to issues that are not in dispute. So there was a student, I believe, who told us about Ms. Petunia Fenter, the fact that she's a major and where she resides. Those kinds of things are not in dispute. So you are taking your own time that you have, and you are also taking our time, because now we have to listen to you speak about this thing that is not in contention. So when you look at the set of facts and when you feel that it is really necessary for your argument that you have to make reference to something in the set of facts, please make sure that it is of relevance, it is an issue that is in contention, and it actually adds to your argument, because other than that, you are wasting time. With the reiteration of the facts, please do not do that. You need to make sure that you know the facts really, really well, because we know the facts really, really well. So if we can pick up that you don't know the facts really well, or you get something wrong in the set of facts, I know that a lot of confusion was students making reference to Mr. Pietrus and the fact that he saw it or he didn't see it, or it was Julia who saw it, just small kinds of things like that. And also then Miss Janine. There was a student who said that Miss Janine had said that she had had something to drink at the school function. She admitted that she was drunk, and that was indeed not the case at all. We are able to pick up on things like that, and that takes away from your case, because if anything, if you are getting the set of facts wrong or you're not thoroughly acquainted with it, what does that say for the rest of your argument? Because if the foundation is wrong, then the research that you did to substantively argue that case, what is that premised on? So that's something that I want to make you guys aware of. You need to know your case so well. If I say to you, okay, counsel, please point to us, or please tell us what happened here, or when the set of facts does this say this, you should be able, off the top of your head, to say to me, this is how it happened. So that's the first thing that I want to make reference to. The second thing, the other points of court etiquette that everyone else has touched upon is very important. But another thing that I want you to be mindful of, and this is also something that Mr. Herman Durant mentioned in our training, is that when you, because this is happening virtually, you still need to be aware of your body language. So when you speak to me, please don't do this. Don't be like, yes, Your Honor, and just be very still, be very straight up, and try your best to make eye contact with us. That's something that I want to ask you to please remember, but that's about it from court etiquette from my side. Then another thing that was touched upon is referring to the presiding officers with the correct terms. We had a lot of students who refer to us as Your Honor. I myself, I believe there were quite a few students who referred to me as my lord, but that is not relevant because we are your worship. Something, and I think this is where the magistrates tried to guide you, where the first question was, counsel, which court are you appearing in, right? And I believe in the set of facts, we explicitly made reference to the Bloemfontein District Court and not necessarily the Magistrates Court, but it is the same thing. But we did not want to give that to you, right? So the first thing is getting the court correct, because if you get the court correct, you are supposed to automatically know what you refer to the presiding officers as. So that is the first thing. Please also remember, in South African courts, we do not use a jury system. So do not refer to judges and the jury. We do not have a jury. The adversarial system that we follow is very different to that occurs in a jury system. So that's the first thing that I want to remind you of. And then another thing that I found was really unfortunate was that a lot of students were able to pick up that we cannot place reliance on these witness statements. No, we shouldn't, the court shouldn't rely on it. However, you didn't motivate that with law. So the underlying principle, the premise, you got that right. However, you didn't authoritatively argue that point. And when we speak of authority, that is what we make reference to. So many of you were saying, no, but you know what? Mr. Peters was not the one who actually saw the alleged person who committed the crime, right? A lot of you were like, okay, but he was drunk. But you did not tell us in law why that was not right. And that leads me to my next point. It is admissibility issues, right? A lot of you understood that no, it wouldn't be right if we actually convicted someone based on these statements. It's not right. But that in itself relates to admissibility, and this is something that I really want you guys to focus on, because the court is not really interested in what you are going to tell us, who you think did it, or why we shouldn't listen. We are interested in whether you can authoritatively back it up. So a lot of students went on to tell us, you know what, this is a character assassination of my client, or it was in fact Miss Julia who did it, or it was that person, or it was that. None of that matters. That is irrelevant. You would have won your case if you simply said to the court, you know what, Your Worship, this evidence is inadmissible. We cannot place reliance on it. It constitutes as hearsay evidence. The exceptions to admitting hearsay evidence in this court does not apply to this matter. Therefore, this evidence the court should not place reliance on this evidence in coming to their finding. It's as simple as that. You don't need to tell me, oh, Miss Petunia Venter, this is where she got the money, or why did that one have the money, or it was in fact Julia who did that. None of that matters, because you are going to win your case if you say to us, you know what, it is inadmissible, because then we cannot place reliance on it. Okay, let me just see what else I made a note of here. Then the last point relates to your use of case law. So whether you guys believe it or not, something we can actually pick up on is whether you actually know a case, the case that you are placing reliance on. I'm not making reference to the set facts, right? So I am able to tell whether, when we ask you, do you have case law, do you have authority, and you say to us, yes, your worship, I indeed do. And then we ask you, okay, what is it and what is the relevance? And then you tell us. But we can tell whether you actually went and read that case and you understand why it is relevant. It's one thing to know the case, to know why it applies or which legal principle is of relevance in this matter. It is another thing if you simply went and you searched for case law that relates to housebreaking or to theft. We can pick it up, right? So when you rely on case law in your arguments, please make sure that the first thing is you understand the set of facts of that case, right? You understand what happened in that case, you understand the judgments, you understand why it's important. You are able to tell us why that is important. Secondly, when we speak of the binding nature of a case, that's something that was also made reference to. But when we speak of the binding nature, please be mindful of the court that you are appearing in. When you read that case, look at where that judgment was made, and then you will see if it is binding on this court. Another thing that I want to make reference to is if it is not binding, remember, with anything that doesn't have a binding nature, it may be of persuasive value. So if you see that, okay, it doesn't have a binding effect, think of how you can use it in a manner to persuade us of your argument, because that is ultimately what it comes down to. You need to tell us that, okay, you know what, Your Honor, we want you to acquit my client, right? Why do you want that? You need to convince us of that. Just the last point. Yes. Something that I picked up when we asked a lot of the students why they made reference to a case or if they indeed looked for a case. So many students said that they searched for a case, they found a case, but they didn't use the case because the facts weren't identical. And that's something you need to be very cautious of, because you are never going to find a case that has the exact same facts as the one that you have to argue. However, you will find certain elements that are identical, or you may find a legal principle that is of relevance, and that's why you still make use of that case. So that's the feedback from me. You guys really did well, and I do believe if you take this feedback and you go back and you look at it, you'll be able to pick up what you could have improved on. But yes, that's it from my side. Over to you, Mr. Mashego.
Alrighty. Thank you so much, Ms. Botha. We are very grateful for the feedback from our judges. And I'd love to believe that they did learn from the feedback and students took the feedback positively. And next time when we have another Moot Court competition, we're not going to see the same mistakes being repeated, but we're going to see an improvement. And now we're going to just have a problem with getting the 8 students, or maybe 10 that time, because they'll be so good. Ms. Botha, can you kindly put the spotlight on me? Now on the
Mr.
spotlight.
Mashego, I do believe the spotlight
Ms.
is
Botha
on
will
you.
also be. You did? Okay, I can see this. Okay. All right. Spotlight is on me. All right. You guys are going to be the judges, right? Everyone is a judge. If you have a question, you need to start by raising your hand. Let us do it in an orderly manner, and Ms. Botha will recognize, or any of the judges will recognize, the previous judges will recognize if your hand is raised, and then they will kindly stop me, and then I will be asked questions by you. This is an extremely exciting experience. I've never mooted virtually, so if I do have a few mistakes here and there, I must be forgiven because I may not even get 100%. But anyway, let me start. If it pleases the court, good morning, your worships. My name is Kamokhelo Mashego, and I will be representing the accused. If it pleases the court, may I kindly commence with my with my opening statement. I would kindly start by stating Section 5 of the Constitution, which stipulates that every accused person has the right to a fair trial. This section was concretized by the Constitutional Court in the case of Feldman versus Director of Public Prosecution. In this case, it was stated that the criminal trials must be conducted in a manner that gives rise to basic fairness and justice. If it pleases the court, may I lead to the court the issues that I will be discussing in my argument? Okay, I see the order. The first issue that I will be discussing is I will be attacking the attacking of the accused person's character evidence, Ms. Fenter, by Ms. Jacobs in her statement. The second issue that I will be addressing is the hearsay evidence that has been provided by Mr. Smith in his statement. And the last statement is the discharge of my witness. If it pleases the court, may I kindly discuss my first issue? The first issue that I will be discussing, as alluded, is the attacking of my character witness by character evidence. I would love to refer the court to paragraph 7 of the set of facts. I am not going to reiterate the set of facts. Justice Searches in the Court of Courts here stipulates that everyone has the right to be presumed innocent before they have been convicted. This statement discredits Ms. Jacobs' statement that the accused stole. Now, this is because the accused, Ms. Fenter, has never been convicted dealing a slow cooker. Thus, she is innocent from such allegations until she has been formally convicted by a court. In addition to the above, Section 210 of the Criminal Procedure Act 51 of 1977 states that no evidence that is irrelevant shall be admissible in any court. We submit to the court that the allegations that attack the character of the accused should be set aside as they are irrelevant because the accused has never been convicted on such allegations. If it pleases the court, may I kindly move on to my second issue? The second issue that I will be speaking on is on hearsay evidence that was provided by Mr. Smith. In my opening statement, I stipulated that everyone has the right to a fair trial. Amongst what is included in the fair trial is the right to challenge evidence. Now, Section 3 of the Law of Evidence Amendment Act of 1988 stipulates that hearsay evidence is generally not admissible because it impairs the witnesses, the other party's right to challenge evidence. If it pleases the court, may I kindly direct the court to paragraph 5 of Mr. Smith's statement. It is clear from the set of facts that Mr. Smith was told by his sister Julia that she saw someone running from the complainant's house across to the accused house, Ms. Petunia. If Julia is not called to the stand to give evidence on what she saw, I am afraid Mr. Smith's evidence will serve as mere hearsay, and it would not be in the interest of justice to admit, as this would affect the accused's right to a fair trial. If it pleases the court, may I kindly move on to my last issue? The last issue that I will be dealing with is Section 174 of the Criminal Procedure Act. This section stipulates that the court may grant a verdict of not guilty if that the prosecution has not discharged any evidence or has not put any prima facie evidence that the accused would be convicted if he does not discharge any evidence. The Supreme Court of Appeal in the case of Lubaka stated that an accused must be discharged at the end of the state's case if the conviction would be possible, if a conviction would be possible if the accused were to testify and incriminate himself. It is clear that the evidence provided by the prosecution did not prove beyond a reasonable doubt that the accused stole the object in contention, we submit to the Honorable Court that may the accused be discharged from these charges as they are not founded on any probative material. We submit that the accused must be discharged without adducing any evidence to the court. This is because there was no shifting of the evidentiary burden. If it pleases the court, may I kindly give the court the prayers and the submissions as concluded. The first prayer is that may this honorable court discard the character evidence as it is of Mrs. Jacobs. The second is may the court kindly discard the hearsay evidence as it is not founded. Lastly, may this honorable court discharge the accused without the accused giving any evidence because there was no shift in the evidentiary burden. If it pleases the court, I have completed my argument and I've given my submissions, and that is my case.
Thank you, counsel. Okay, judges, does anyone have any questions that they would ask? Although Mr. Mashiko has submitted his argument, I just want to find out if there's anything that any student would like clarity on. Ritabile, Cindy, I see your hand is raised. Will you please unmute yourself and proceed to ask your question?
Good morning. I don't have a question for Mr. Mashiro. I do believe that pardon. I do believe that he presented very well, and thank you so much for showing us how to do it properly. I do believe that we only improve from now on. But I do have a question for Miss Botha, if she does not mind.
Yes, please, of course.
Ma'am, during my presentation, I struggled with placing my laptop correctly, as well as giving great eye contact, because at the end of the day, we just look at ourselves and we forget that there are other people that are looking at us. So can you please advise us on that and how to do it properly?
All right, thank you so much, Ritabile. So something that I usually do, and it's something that I actually did before this meeting, is that I make sure that I place my laptop in a way that it is stable and you can see me. Something that happened a lot was people's faces were cut off, so you would literally only see them from here. And that is either because they are too close or the laptop screen is tilted. So just issues like that. I also think that's why, I think with the Moot it was a little different because you weren't able to join early. However, just to sort out preliminary issues like that, you will see before you get the option to actually turn your camera on, when you place your computer cursor on the little camera icon and you just hover it there, you will see that it shows you what you currently look like before it shows everyone else. So that's a great little tip before you actually switch it on, just to make sure that everything is fine. Yes, but that's what I would say. Just make sure that you are comfortable. I do know that some people make use of their cell phones, and I think that may pose a different challenge in that regard. But just make sure that whatever device it is, that it is stable. We are able to see you. Just your connectivity issues are sorted out. That your mic, just that kind of thing. I really hope that that answers your question. Obaking, I see your hand is raised.
I just quickly want to add on with regards to using cell phones. So with cell phones, they're chilling vertically, not horizontally. So ensure that you put yourself or your face in the center of it, because it will actually do this to you when you speak or when you highlight it. It will make it seem like you're using a laptop when you're not. So when you're using your phone, just make sure that you put your face in the middle. You can have a lot of space at the top, that's fine, but make sure you are literally at the center of your cell phone screen, and then you'll be able to fit yourself properly in the proper space needed for you to be seen.
Thank you so much, Obaking. Rita Villa, I see your hand is still raised. Can you please just tell us whether your question has been answered? All right. Thank you so much. Then I just realized while Obaking was speaking that there's something I didn't make reference to, right? So the eye contact component. So what I really mean with that, and I think this is also something you guys should take note of. Please, if it assists you in writing down your argument, then by all means do so. But please do not come to the court and read your argument to us. So this is what I mean when I say eye contact, right? So I am addressing the presiding officers. However, I'm not looking at them because I'm too busy reading here. So when I say eye contact, that's just what I mean. Just this. You can obviously look down just to make sure you're still on track. That is fine. We're not unreasonable. But when I say eye contact, just please make sure that you are. Okay. So Nobelungu, I see that you have a question.
Hi, good morning, everyone. I don't really have questions for Mr. Mogelo Mashego because his presentation was very great. I just want to know, when presenting, you have to prepare the opening and the closing statement only. That there's no need to prepare questions. That's what I want to know.
Can I kindly answer that, even though I'm supposed to be over there in court? Nobelungu, you were supposed to. We even did give people chances to just allude to us the questions. I did ask a few students what kind of questions are you asking, and there was a student that was good enough to note that these are leading questions because I'm cross-examining these witnesses. Yes, that is important. We want to see how you're going to discredit the witnesses. But what was more important is you giving us the law, right? And the reason why I didn't go on into cross-examining and things like that is because I just wanted to discredit the witnesses on the law, right? Which is what is more important than really questioning the witness. So are you answered?
Yes, I'm answered. Thank you very much.
See, I can still answer questions. Guys, this was supposed to be an exciting session. You okay? There's Krista. I hope Krista, you have a question. You have a question for me, please.
Good morning, everyone. I have a question for you. You were very good, and we were looking up to you, so we're following your steps. Don't get me wrong. But I just want to understand, when you give a legal argument, what is can you give us a structure that we need to follow or something? Do you start with the case or the legislation and then your basic ideas and then I don't understand what to follow when you want to make a legal argument?
Ms. Potter, do you want to answer that or should I answer it?
No.
Based on my argument. Okay, based on my arguments, I basically refer to legislation. But when we look for legislation, there are certain cases that refer to certain sections of the legislation. And you will see with time when you do statutory interpretation, you will see how the courts construe different legislation. So how the courts apply different legislation to the set of facts, right, to the particular facts that was to the court. So the reason why for me, it would be best for you to start by giving me legislation. This is what section 31A or let me say 31C of the Law of Evidence Amendment Act stipulates about hearsay evidence and how it will be admitted when it is in the interest of justice. Now, with you, when you get to me and be like, okay, yeah, it is in the interest of justice, one of the questions that I was expecting from you guys is, what is the interest of justice, Mr. Mashego? What do you mean when you're telling me that it is in the interest of justice? And then I come to you, I said there was a case by the Supreme, that was heard by the Supreme Court of Appeal. It was S versus Shaik. I'd love to believe. I'll send in the case, the Supreme Court of Appeal case, right? In the Supreme Court of Appeal, so what the Supreme Court of Appeal explained the interest of justice to be is that if every single evidence that is presented to the court points at Ms. Petunia Fenter as her being there and committing the crime, then it is in the interest of justice to say that, to admit such hearsay evidence. So that is what happened in that case. Every single circumstantial evidence that was present there pointed at the accused. And then the question now arises, is it in the interest of justice to admit this hearsay evidence? We've got ballistic evidence, we've got forensic evidence, we've got let's say there was a fingerprint on the brick, there was a fingerprint on someone that unlocked the door, there was someone was able to clearly identify that was Miss Petunia Fenter that was running across the road or running across the street like a headless chicken. Then it is in the interest of justice then to admit such evidence, right? Because every single thing is pointing at what? At her. That is what we speak about when we say the interest of justice. And are you answered, Ms. Christo? I go in deep. I go in deep when I explain, and I'm sure now I am tutoring and I need to get paid for this because I do get paid for tutoring. So are you answered? So I'm sure some of you presented the state, and you guys must be asking yourself, okay, what was expected for the state? What was the expected? The argument of the interest of justice that I'm giving you guys was what was expected from the state. Discuss the interest of justice to us. What is the interest of justice? And what if we say, let us call, the state is intending on calling Miss Julia, right, to concretize what she told Mr. Smith, then guess what? The hearsay evidence is admissible.